All right, welcome future barristers. If you're gearing up for the Queensland bar exam, you already know about one of the biggest challenges, trying to master the two parallel universes of evidence law. So today, that's what we're doing. We're building your playbook to tackle it head on.
You know that feeling, right? One minute you're applying a strict common law rule, the next you're trying to navigate the Commonwealth Evidence Act. It feels like a minefield, and frankly, it's designed to trip you up when you're under pressure. So think of this as your strategic map. It's how you get through it cleanly and with confidence.
Look, to really master this, you have to get the two fundamentally different philosophies that are at play here. Think of the Commonwealth Act as having wide gates. It is designed to let a lot of evidence in. But, and this is the crucial part, to balance that, it also has strong guards. We're talking about powerful judicial discretions to throw that evidence right back out. Queensland, on the other hand, is much more traditional. It has stricter, more rigid rules from the very beginning. Seriously, if you can grasp this one concept, wide gates, strong guards, it is the key that unlocks everything that follows.
So, here's our game plan. First, we are going to dive into the great hearsay divide. That's where the differences are just massive. Then, we'll cover some really critical distinctions in things like admissions and opinions, before we tackle the super powerful tendency and coincidence rules. And then, at the end, we'll pull it all together into your exam day playbook.
Okay, let's get right into it, starting with hearsay. This is where you'll find the absolute deepest chasm between the two regimes, and it's where exam points are so easily won or lost.
The Commonwealth's gate is especially wide in civil cases when a witness is unavailable. You see, Section 63 lets in their first-hand hearsay whether it's spoken or written. But you know, the real game changer here is the Commonwealth's definition of unavailable. It doesn't just mean the person isn't physically there. It can actually mean the person is sitting right there in the witness box but has no memory of the event or even just flat out refuses to answer. That is a huge departure from the much stricter Queensland approach.
And this wider approach, it continues even when the person who made the statement is available. Section 64 gives you these gateways, letting you argue for admitting their prior statement if, say, calling them would cause undue delay or expense. And even better, you can often get a prior statement in if it was made when the event was fresh in the memory. Now, that is a powerful tool that just doesn't really have a direct equivalent in Queensland law.
Now, in criminal law, the gates do narrow a bit, but they definitely don't slam shut. For an unavailable witness, Section 65 of the Commonwealth Act gives you 5 specific, absolutely crucial exceptions that you must know for the exam. For instance, if a statement was made under a duty, or it was made in circumstances that make it highly reliable, well, it might just get in.
So this brings us right back to our central theme, doesn't it? If the Commonwealth's wide gates are letting so much hearsay evidence in, how on earth does the Act ensure fairness? Well, it's all about the strong guards, those powerful judicial discretions to throw evidence out. Mastering this second half of the puzzle is absolutely critical.
And here they are, the strong guards themselves. Sections 135 to 137, these are going to be your best friends when you're trying to exclude evidence under the Commonwealth Act. So even if a piece of hearsay technically fits an exception, you can still stand up and argue it should be tossed out because it's unfairly prejudicial, or, just a plain waste of the court's time. And in a criminal case, Section 137 is the big one. If the danger of unfair prejudice outweighs its probative value, it's out. Simple as that. Okay, let's pivot and look at a few other areas where the Commonwealth Act really carves its own path, starting with something as practical as business records.
So, the Commonwealth Section 69. It simplifies things quite a lot when it comes to business records. But don't get complacent. You see that little proviso down there? A record can't have been prepared for litigation. That is a classic exam trap. If a document was created because someone had an eye on a future court case, Section 69 is not going to help you, no matter how much it looks like a standard business record.
The Commonwealth Act also does a lot to modernize the law on expert opinion, and in a really significant way. Section 80 completely abolishes that old, frustrating ultimate issue rule. What this means is your expert can now give an opinion on the very question the judge or jury has to decide, like, for example, whether a person was negligent. This is a massive, massive departure from the common law.
We are now entering one of the most persuasive and, because of that, one of the most dangerous areas of evidence law. This is where you're trying to prove someone did something because, well, it's in their character, or they have a tendency to act that way.
This right here, This is the raw, intuitive logic of tendency evidence. It's incredibly powerful in a courtroom, which is exactly why the law puts such strict controls on it. The Commonwealth Act codifies these controls in sections 97 and 98, and they set out exactly when this kind of reasoning is even allowed.
So the Commonwealth Act sets up this really critical two-stage balancing act. First, for the prosecution to use tendency evidence, it has to have significant probative value under Section 97. Okay. But then it faces an even tougher hurdle at Section 101. The evidence's probative value has to substantially outweigh its prejudicial effect. And I'm telling you, that one word, substantially, that is everything. It sets a very, very high bar, and it's a key difference from the common law test.
And this leads us right to the related coincidence rule. And this quote from the famous Folbig case just nails it. The core question becomes, are these separate events so strikingly, so remarkably similar that it just defies common sense to think they all happened by chance? It's all about ruling out coincidence through an incredible, almost unbelievable pattern of similarity.
Right, we've covered the main battlegrounds. So now let's pull all this intelligence together into a clear, strategic playbook that you can actually use to attack any evidence problem on your exam.
Okay, for any Commonwealth problem, I want you to keep these 3 steps right at the front of your mind. First, your mantra. Wide gates, strong guards. Find the rule that lets the evidence in, then immediately pivot to the discretions to get it thrown out. Second, remember that hearsay is the main game. If you can master sections 63 to 66, you will set yourself apart. And finally, a really practical tip that can save you. Always check the notice provisions. Forgetting those is just an easy way to lose marks.
And as you're committing all of this to memory, I want you to think about this. These aren't just abstract rules for an exam, are they? They literally shape the kind of advocate you are going to become. Are you going to be the barrister who cleverly uses the wide gates to get that crucial piece of evidence before the court? Or will you be the staunch defender who masterfully wields the strong guards to protect your client from prejudicial material? Your journey, it starts with mastering these 2 systems, right now.